we have a constitution, and the constitution is not an opinion of any person. It is the document which is binding on us. So what I wrote on social media was actually the obvious, because we have a lot of people who think laws are suggestions which you can negotiate the way you want. And when I said that the abuse of something is not an argument against its proper use. Look at fire. We use it for cooking, for warming ourselves, but there are those who commit arson using fire. Would you now say, I hereby ban fire because it is being used by criminal-minded people to burn houses? It's our duty to go back to the Constitution. And incidentally, let's look at laws as rules and regulations. But also let's look at the legal environment in terms of standards. The Constitution of Uganda sets a very, very high standard. It says that there shall be no derogation from the Constitution except the ones that are acceptable and demonstrably justifiable in a free and democratic society. So the Ugandan Constitution is inviting the whole world to judge us. Because when you say in a free and democratic society, that is the standard. So the courts should not hesitate. It's actually their duty. Some people think it is the role of the Minister of Justice to declare to interpret laws. It's not my job. My job is to serve the executive branch, and we execute laws. And when we execute them wrongly, the courts do the job of referees and linesmen, so that when we cross the line, they say you have crossed the line. And the line in a football pitch is not negotiable. Fortunately, now we even have VAR. So you could say the Supreme Court is really the VAR. It is up to them to tell us whether what is going on meets that very high standard that is in the Constitution. So I know for a fact that what you are talking about as a ruling, it can't be a ruling. When an accused person keeps quiet, the law says that a plea of not guilty is entered. And I think the court wasted a lot of time insisting on repeatedly. If somebody says, I reject your jurisdiction, I don't believe that I'm rightfully before this court is illegitimate, that is part and parcel of the right of an accused person to give their own judgment. The duty of the state to quickly go to the business of proving their case. Remember, part of a fair trial is speedy trial. By the time you drag somebody in handcuffs to the court, surely you must have the evidence locked in, and then you call witnesses and prove your case. Normally, after that, the accused person can say, I submit that there is no case to answer. Then the bench has to rule on that, whether there is a case to answer or not. So those antics are totally unnecessary. We expect the state to be very serious in prosecuting suspects, and our standard also is presumption of innocence. And if you are presumed to be innocent, then it is not necessary to project you as if you're already an accused person. In America, for instance, there's this guy who shot somebody in broad daylight. Hundreds of lawyers queued in front of the court to defend him. For them, they think the man did a good job because this person was a hated figure. Not that they believe he didn't commit murder, but they probably will go and say, now there should be sentencing maybe the charge should be manslaughter and so on. They will bring all sorts of technical arguments. But the court has spent so much time discussing all sorts of things, starting with the drama of getting a mere piece of paper to have the right to appear, which is basically clerical work. That decision should have been made at the reception of the Law Council to say, sorry, we can't, because the Law Council has big people. The receptionist should have said, this thing is not notarized. We don't have copies of the recommender's practicing certificate. Please go back and put your papers in order, instead of forwarding incomplete files. So the whole drama is totally unnecessary. If indeed Colonel Besigye has committed an offense and the state has evidence, the trial should go on at top speed.